Hey guys and gals, this is the Bar Exam and Chill podcast. I'm your host TJ, and today we have a hypo from the California Bar Exam. This is from the test administered on February 2018. But before we jump into the hypo, I just have a quick show-related announcement. I set up a Patreon, so if you're finding this useful, I'm going to keep releasing the episodes for free on YouTube. The 7 MBE topics I will be releasing for free on YouTube. On the Patreon, you're going to find that I release the topics outside of the 7 MBE topics. So I'm going to be going through like business association hypos, secured transactions, and the other topics that are outside those 7 MBE questions, which I'm going to keep releasing previous essays for free on YouTube for the 7 MBE topics. I also have on the Patreon some outlines. I have the outlines that I used for the UBE and the California Bar Exam. Those are on sale, single purchase. So if you just want to buy an outline, that'll help the show out. Or if you want to buy into the monthly tiers, there's 2 tiers, and those are just going to be, the first tier is going to be all of the audio podcast episodes outside the 7 MBE topics. If you want some essay help outside those topics, like I said, for secure transaction, family law, trust and estate, business associations, all those related topics outside the 7 MBEs. I'll be releasing that via the Patreon. And then also I'm going to have a tier for if you want access to the outlines, and I will have some AI prompting ideas. I went through some of the previous prompts that I gave to AI as I was studying, and I'll be releasing that all for paid subscribers. So if you want to help the show out, that'll be a great help. Otherwise, I'll keep releasing these episodes for free on YouTube, only for these 7 MBE topics. All right, today we've got an essay question from the California Bar Exam. This is from February 2018. Let's jump right into it. Claire, a 4-year-old girl, went missing. Ike, who regularly provided reliable information to Officer Ava, told her that he had recently overheard Don planning to kidnap a child to raise as his own daughter. Officer Ava's partner, Officer Burt, hurried to the courthouse to apply for a search warrant for Don's house. Meanwhile, Officer Ava rushed to Don's house and knocked on the door. Don answered. Officer Ava told him, quote, "I heard that a missing child might be here," and asked, "Can I come in and look for her?" Don replied, "No." Officer Ava said, "A life is at stake. I am searching your home whether you want me to or not." Don stepped aside and allowed Officer Ava to enter. Officer Ava searched the home thoroughly. In a closet in the bedroom, she found a bomb, measuring about 2 feet by 2 feet. In a medicine cabinet in the bathroom, she found several vials of cocaine. While looking under the bed, she found a plain sealed envelope, which she opened. That contained a map with a highlighted route from Don's house to Claire's house. She did not find Claire. Immediately after she completed the search, Officer Burt arrived with a warrant authorizing the, quote, search of Don's home for Claire. Not long afterward, Claire turned up elsewhere unharmed. Don was charged with 1. Possession of a bomb, 2. Possession of cocaine, and 3. Attempted kidnapping. Don filed a motion under the 4th Amendment to the United States Constitution to suppress evidence of the bomb, the cocaine, and the map. Question 1. How should the court rule on the motion to suppress regarding A. the bomb, discuss, B. the cocaine, discuss, C. the map, discuss, and question 2. Can Don be found guilty of attempted kidnapping, discuss? Awesome, so let's jump into this. So to set the foundation for the evidence questions, we must first establish the overarching rules regarding the 4th Amendment, right? The initial entry into Don's home and the exceptions to the warrant requirement. So our overarching 4th Amendment principles rule that we want to have memorized for the bar is: the 4th Amendment protects citizens against unreasonable searches and seizures by the government. A search of a home is presumptively unreasonable without a valid warrant supported by probable cause. For a defendant to challenge a search, they must have standing, and this means a reasonable expectation of privacy in the place to be searched. So this rule has some exceptions, right? There are some exceptions to the warrant requirement. Let's go through the exceptions to the warrant requirement. Number 1, you've got consent. A warrantless search is valid if the police obtain voluntary consent. However, Mere acquiescence to a claim of lawful police authority is not voluntary consent. So there's your first exception there, consent. Number 2, exigent circumstances. This is probably the most used, right? Police may enter a home without a warrant to render emergency aid to an injured person or to protect a person from imminent injury. For example, if you've got like a kidnapped child whose life is in danger. Okay, the scope of a search justified by exigent circumstances is strictly limited to areas where the object of the search, in this case in our hypo, a child, could reasonably be found. And number 3, this is another exception to the warrant requirement, you have the plain view doctrine. So police may seize evidence without a warrant if they are A, lawfully present in the area where the evidence is found, and B, the item is in plain sight, and C, its incriminating nature is immediately apparent. All right, so we've got our rule for the Fourth Amendment and these exceptions to the warrant requirement. Let's talk about our overarching application to the initial entry in our hypo. All right, so Officer Ava is a government agent, right? She's a police officer. Don has standing because it's his home. That's where your reasonable expectation of privacy is the highest, right? In your home. So you're going to have standing to challenge a search if it's of your home. And if you do that, one of these exceptions to the warrant requirement is going to have to apply. So Officer Ava did not have a warrant when she entered. We're given that in the facts. When she asked to enter, Don explicitly said no. So he's not consenting. So, we go through that first exception. Do we have voluntary consent? No, not here. He said no. She then stated, quote, "I am searching your home whether you want me to or not." Don steps aside, and this kind of seems like it's a submission to her claim of lawful authority, but it's not voluntary consent. So that's key. He clearly stated no, and stepping aside is just him acquiescing, right? So that's not going to be enough for voluntary consent. Therefore, the entry must be justified by either exigent circumstances or this other exception, the plain view doctrine. So, because Ava had reliable information that Don planned to kidnap a child, or that he had kidnapped a child, and a 4-year-old was currently missing, she reasonably believed that a life was at stake. This is going to be what the officer argues justifies her warrantless entry into the house, right? Because it's an exigent circumstance, it's an emergency. She's going to say, I had to lend aid and try and find this kidnapped child. The exigent circumstance here might be a close call, but we've got a missing child, and it's a reliable tip about Don's plans. So the officers are going to arguably, maybe they've secured the perimeter. Well, they could maybe arguably secure the perimeter and wait for the warrant, which is coming behind this other officer. I think his name is, what is his name? Baker? Officer Burt. Officer Burt comes behind. He's got a warrant, right? But we're not given that yet. So Officer Ava arrives. She doesn't have a warrant. She basically just barges into the house. So she's going to argue that she's got exigent circumstances. The other side is going to argue, hey, she doesn't have enough. She doesn't have, there's no child screaming in the background. How does she know that there's this kidnapped child? The officer's going to say there's a life in danger. So I have to come in, and it's justified that I entered without a warrant. A little bit of a close call, but if you look at the case law, it is that if there's a kidnapped child or there's a life in danger, the courts are going to give a little bit of deference to the officer. So it's likely here that exigent circumstances are going to apply. But if we come down on the other side and we say, hey, she only had a tip, basically, and that's not enough to enter the home. There's no screaming child. She has no idea if there's a kidnapped child on the premises. If we come down on that side and say there's no warranted exigent circumstance to get around the warrant requirement, then we have this other exception here, which is the inevitable discovery doctrine. Here you've got Officer Burt coming from behind, and he's got a valid warrant. So, they could secure the perimeter and wait for Officer Burt to arrive, in which case they're inevitably going to enter the home and do this search, right? So you've got two ways to try and get around the warrant requirement here. One of them is exigent circumstances. It's likely that a court is going to hold, hey, a kidnapped child, that's going to suffice to get around the warrant requirement. Or alternatively, you could argue, hey, there's this inevitable discovery doctrine. The evidence would have been found lawfully had Ava just waited and Burt arrived. Even assuming the entry and overall search were justified, the scope was limited to searching for Claire, right? This child. So the search has to be something that a child could be hiding in or could be caged or trapped in, right? That's going to be the scope of their search. When they enter the home, they're not going to be able to search in things that like a child couldn't fit inside, basically. So a bedroom closet is plausible. That's a plausible place to hide a child. So searching it was within scope. Once lawfully in the closet, the large 2x2 bomb was in plain view. So plain view allows seizure of that item, whose incriminating nature is immediately apparent. So that's going to be our first application here, right? 1A, motion to suppress the bomb. Our issue here is, did Officer Ava exceed the scope of her lawful exigent circumstances search when she looked in the bedroom closet and seized the bomb? So our rule is, as stated above, the scope of a warrantless search under exigent circumstances is strictly limited to places where the person or item sought could reasonably be found. Under the plain view doctrine, if an officer is lawfully looking in an area and sees contraband, they can seize it. So our application, Officer Ava was lawfully inside Don's home, as we've established, under the exigent circumstances to look for Claire, a 4-year-old girl who had been kidnapped. Because she was looking for a child, she was legally permitted to open doors, look in spaces large enough to hold a 4-year-old child. A standard bedroom closet is more than large enough to hide a kid. So therefore, Officer Ava was lawfully permitted to open the closet door and look inside. While lawfully looking in there, she saw a bomb measuring 2 feet by 2 feet. Assuming the incriminating nature of a 2 by 2 foot bomb is immediately apparent, as bombs generally are contraband and dangerous, she was permitted to seize it under the plain view doctrine. So our conclusion here is going to be, the court should deny the motion to suppress as to the bomb, because she was lawfully there under exigent circumstances, and the plain view doctrine allows her to seize the bomb as evidence. All right, great. So there's our 1A. 1B here, motion to suppress the cocaine. Did Officer Ava exceed the scope of her lawful, this is our issue, did Officer Ava exceed the scope of her lawful search when she opened the bathroom medicine cabinet? Well, our rule is going to be, a search conducted under exigent circumstances must be strictly tailored to the exigency. Officers may only look in areas capable of holding the object of the search. Here, it's the child. So our application is going to be, Ava's sole lawful justification for being in Don's home and conducting a search was to find Claire, who's this missing 4-year-old. While a child can fit in a closet, it's probably physically impossible for a 4-year-old to fit inside a bathroom medicine cabinet. Therefore, opening the medicine cabinet exceeded the permissible scope of her emergency search. Because she was not lawfully permitted to open the cabinet, the plain view doctrine does not apply to the cocaine found therein. So here's a little side note on this inevitable discovery doctrine. Officer Byrd arrived shortly after with a warrant. However, the warrant explicitly authorized a search of Don's home for Claire. Therefore, even executing this warrant with probable cause, the police would not have been legally permitted to look inside the medicine cabinet for a child. Therefore, the inevitable discovery doctrine is not going to save the evidence, and it exceeds the permissible scope of the search under the exigent circumstances doctrine. So here, our conclusion is going to be, the court should grant the motion to suppress the cocaine because it exceeded the scope. Nice. Let's look at 1C here. Motion to suppress the map. Our issue is going to be, did Officer Ava violate the Fourth Amendment when she opened the plain sealed envelope found under Don's bed? Well, again, our rule is going to be, the plain view doctrine does not allow police to open or manipulate items to discover their incriminating nature. The illegality must be immediately apparent from the outside. Furthermore, the scope of a search is limited to where the object of the search could be found. So here, our application is going to be, Officer Ava looked under the bed. Because a 4-year-old child could hide under the bed, okay, she could look under the bed, right? However, she found a plain sealed envelope. It's a plain envelope. There's nothing on it, right? That means there's no text saying like, hey, here's some illegal shit in here. While she was lawfully looking under the bed, she was not permitted to open that envelope. A 4-year-old child can't fit inside a sealed envelope, right? So this would exceed the scope of the exigent search for the child. Furthermore, plain view doctrine does not apply because the envelope was plain and sealed. It's not saying, hey, here's some illegal shit in this envelope, right? So our conclusion here is going to be like B, the court should grant the motion to suppress the map. Nice. Those are our objects here. Let's move on to question 2. Question 2 is, can Don be found guilty of attempted kidnapping? So our issue is, did Don possess the requisite specific intent and commit a sufficient overt act to be found guilty of attempted kidnapping. So did he have the requisite specific intent? Kidnapping is a specific intent crime. And did he commit a sufficient overt act to be found guilty of attempted kidnapping? That's our rule, right? Our rule is going to be for attempt, you require 2 elements. Every attempt crime. These are called inchoate crimes as well, but you might have a heading, right? You bold it, inchoate crimes attempt. Our rule here is going to be criminal attempt requires 2 elements. 1, specific intent to commit the target offense, here kidnapping, and 2, an overt act in furtherance of that intent that constitutes a substantial step, there's your quote for the bar, beyond mere preparation. So kidnapping is defined as, this is our rule statement for kidnapping, unlawful movement of a person by force or fear. Mere preparation here, such as planning, gathering materials, or mapping a route, is generally going to be insufficient to constitute a substantial step for purposes of an attempt crime. Okay, so our application here, what's our intent? We got first prong of the attempt crime. Do we have the specific intent? Prosecutor has evidence of specific intent, right? Ike is a reliable informant. He overheard Don explicitly planning to kidnap a child to raise as his own. Okay, so we may have specific intent, right? He's expressed the specific intent to kidnap the child, raise it as his own. Do we have an overt act that would constitute a, quote, substantial step? There's your key word, right? You might want to bold this in a throwaway title here really quickly, substantial step, and then you would analyze under that, is there a substantial step? So overt act. The issue is whether Don took a substantial step toward completing the crime. Don's action consisted of verbalizing a plan and highlighting a route on a map from his house to Claire's house. While this shows preparation and a targeted victim, Don had not actually left his house, approached Claire, or attempted to take her. We're going to say, mapping a route is a classic example of mere preparation. So this is how they distinguish these in the cases. Mere preparation is not going to be enough for an attempt crime. You have to take this substantial step. So is this a substantial step? Likely no. It's probably, quote, mere preparation. Have a little evidentiary note here. Even if the map was considered a substantial step, the map will likely be suppressed under the Fourth Amendment, right? As we set up above. This leaves the prosecution with only Ike's statement about a general plan, which falls drastically short of proving an overt act or a substantial step. So here our conclusion is going to be, we're going to come down forcefully. Don cannot be found guilty of attempted kidnapping because his actions amounted to mere preparation, not a substantial step. So those are your key words in an attempt crime. You've got either mere preparation or a substantial step, and you analyze under those standards. We're good to go. We answered this bar question. Again, if you want to support the show, if this is helping you out, I've got a link to this Patreon down in the YouTube here, or in Apple Podcasts, whatever you're listening on. There will be a link in the show info. Go to that Patreon and throw us some bucks if we're helping you out. All right, thanks so much, you guys. Happy studying.